Good morning. I've been engaged with a sovereign citizen over whether or not you can assert your Fifth Amendment privilege against self-incrimination when asked to identify. My position is that there is no good reason to suggest that you can. There is not one case ever where the Fifth Amendment has been applied to your name. It has been tried, it has been tested, it has been rejected multiple times over and over again. His position is that Hybl allows it because he's a sovereign citizen and he can't read. What Hybl suggests is that at the very end, in dicta, which means that it's not part of the case, it's not in front of the court isn't deciding on it, and the court expressly says it's not deciding on it. But in dicta, it says that someday, very last paragraph, someday there may be a case where somebody's name provides a link in the chain of evidence. There's two ways basically that you could implicate the Fifth. One is where, like if the police say, did you rob the bank? You can take the Fifth because saying yes will obviously implicate you directly in that crime. Link in the chain of evidence would be where the cops ask you, where did you sleep last night? You may have slept at your girlfriend's. It's not a crime to sleep at your girlfriend's. However, if you left the gun and the mask that you committed the bank robbery with there, then telling them that you slept at your girlfriend's might lead them to evidence of the crime. And that could also be protected by the Fifth. Now, your name has never been found to do either. And in fact, it's precluded from being the former because it is never a crime simply to be you. It's not a crime to be John. It's not a crime to be you. You may have committed crimes, but it's never a crime just to be you. So, the court is saying that someday, we haven't found it yet, but someday, there might actually be an instance where your name is a link in the chain of evidence. At that point, a court, whatever court that this particular situation is in front of, can determine if the privilege applies. Does the Fifth Amendment even apply to your name? And if so, what remedy? But that's not in front of the court. That's what Hybl says. But that's not in front of this court today. So does that mean that you can assert the Fifth ever for your name? No, because at that time, the lower court gets to determine if the Fifth Amendment even applies. Now, what does that mean? Well, you got to kind of have an understanding of the case law surrounding it. In the probable cause version, not the reasonable suspicion version that Hybl was looking at, in the probable cause version, where you've been arrested, you can't refuse to give your name. And it's gone to the Supreme Court, and 4 justices said there's simply a booking exception. So you can't refuse to give your name in a booking situation because that's just record keeping. I mean, they're not interrogating you. The other 4 justices said, well, no, names are just non-testimonial. The Fifth Amendment only protects you from giving testimony. Giving your name is not giving testimony. So if names are testimonial, then the Fifth Amendment, even if it otherwise should apply, won't apply. If there's an exception, even if the Fifth Amendment should apply, it won't apply. Either one of those two situations, if they win, wouldn't apply. So the court in Hybl's not saying that it will apply or that it should apply. They're just saying that at that time, a court can determine if it will apply. And what remedy? Because here's the sad fact, kids, you can't exclude someone's name from a civil or a criminal case. The defense defendant, I guess technically for the defense side, the respondent or the defendant, their name can't be excluded. So if they get your name, despite your Fifth Amendment demand, they can still bring it in. It cannot be excluded. And that is a Supreme Court case, INS v. somebody. I don't know. I'm going to say Lopez Menendez, Lopez something or the other. I want to say Lopez something. It's a hyphenated name. Anyway, it originated out of the Ninth Circuit. So there you go. But yeah, it doesn't matter. It doesn't matter if the name was procured as a result of an illegal search, an illegal seizure, or an illegal interrogation. Doesn't matter. You can't exclude the name. So what remedy would even apply? And finally, let's just talk turkey here. Number one, it's not a search to take a picture of someone and run their face through facial recognition. The Fifth Amendment wouldn't apply. The Fourth Amendment doesn't apply. It's just not a search. That's a Supreme Court ruling. Fingerprints, taking someone's fingerprints, not a search. I mean, you might have to seize them to get the fingerprints, but if the cops are already stopping you, and if the cops already have a statute that says they can demand your name, if they have reasonable suspicion, then, well, they have a reasonable suspicion, which means that they could stop you. I don't want to walk past that. Which means that they could stop you. And if they can stop you, then they can get your fingerprints. That is not a seizure. And of course, they could identify you off of your face or off your fingerprints. But what is most likely to happen is that you're going to catch a charge. If they have a statute saying that they can demand your name with reasonable suspicion and you have to provide it to them, that means that there's going to be some sort of a penalty for not providing them your name. Stating that you're going to take the fifth is guaranteed. I'm going to guarantee it won't work. Even if you think you have all the, even if you think it's a link in the chain of evidence, it's not going to work. So what's going to happen is that you're just going to eat another charge. They're going to take you to booking. They're going to get your name anyway, because they're good there. Once they have your name, it can't be excluded. So what are you going to do? I mean, it's just, you're just being silly. And it's that whole sovereign citizen thing of not only misreading the law, but not having a good grasp of the law surrounding that particular case, why they're saying the things they're saying, just interpreting into it what you want to hear. Obviously, the sovereign citizen wants to hear that he could take the fifth when his ID is demanded. And there is no authority to support that proposition other than Hybl saying, it's not in front of us today. We're not deciding that today. And that's what Hybl is saying. We're not deciding it today. It may or may not fly, but that's not in front of the court. So there you go. I hope everybody understands that. Much like resisting arrest, even, you know what, you actually have a better chance of using force to resist an unlawful arrest and getting away with it than you do with not providing your name and claiming the fifth. Because I've seen people get away with the using the force thing. There's no example of anybody getting away with taking the fifth on their name. And now I just want to be perfectly clear. I am not advocating that anybody resist arrest. Your odds of getting away with that are somewhere in the super slim range. So don't. You'll get hurt. And, the odds of you surviving long enough to actually sue and win, or to surviving long enough to suppress the evidence or quash the arrest or whatever, just so super slim. So don't do it. Anyway, thanks for watching. Have a great day.